I should introduce myself. My name is Ann Barker. I'm one of the Research and Instructional Services librarians at Ellis Library. I specialize in language and literature, and since around 1998, when I came, I was asked to sort of be the copyright troubleshooter for the library. So I know a little bit about copyright. I should make very plain that I have no legal credentials, so I have no authority to give you a legal opinion. I would refer you to General Counsel's office, and I'm glad we've got, is it Lana? Is that, am I pronouncing your name correctly? So she's here from the General Counsel's office, so I can give you sort of a general framework of my understanding of the copyright law and how I think it's helpful to think about it, and some information sources, and sort of a process to go through to see if what you want to do seems to be a fair use or seems to be covered by the educational exemptions, and when you might need to go get additional legal counsel and get some advice if you get into something that's a little more sticky. So that's my goal for today. We have an online guide to copyright that we'll pull up, and I'm just going to kind of walk you through that guide and then handle any questions. We can try to work some scenarios and see how that works out for you. And sort of give you an idea of where to go. Does that sound on target for everybody? Everybody hear me okay? People online are connecting all right? Okay, super. Well, if you're at the library's webpage, it's pretty easy to find our copyright page by using this search box. So not the general search box at the very top of the screen, but the search box for the library's website. Just type in copyright. And the top thing that comes up is our copyright guide. Or you'll see the URL for this is also libraryguides.missouri.edu/copyright. So we're looking at copyright mainly in an educational context, so there's a lot more to do with copyright, but we're focused on the sorts of things that seem to come up in our particular environment. And I should mention, I feel like I'm fairly comfortable with the code, the statute, some of the regulations. When you get into case law, that's constantly evolving, so it's always changing, and how the law gets interpreted in different cases from circuit to circuit might be a little bit different too. So that's where if you get something that's a little bit beyond the normal things we see, you might need to get some more help. I think it's helpful to sort of first focus on sort of the copyright basics. This is just sort of a general outline of what the law is about, why this has come about. And that gives you kind of a framework to think about. I think a lot of people get sort of intimidated by copyright. A lot of people would like to have very hard and fast rules. And the law is actually designed to be a little bit more flexible, so it's helpful to understand the context and kind of what the intent is, where it's trying to go, and that helps you figure out more what your goal is, rather than having like, it's this many pages, this many images, and so forth. So copyright is enshrined in the Constitution. The purpose is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So it's a little bit of a balancing act. The idea is that people put effort into creating something. They should be able to get a return on that creative investment, but it's for a limited time because we know new creations are based on creations of the past. So we also want people to be able to use stuff to transform it, make new things. So it's sort of for a limited time. The limited time has grown over the years. So it started out, it was just 14 years with the possibility of renewing for 14 years. And then over time, it's gotten extended longer and longer and longer till now the standard is 70 years after the death of the author. So it's actually not the return to the creator, but the return to the creator's heirs, which is, some of us have funny feelings about that. It covers original works of authorship that are fixed in any tangible medium of expression. So for example, a telephone directory doesn't have a lot of originality, so it's not covered by copyright. My speaking into the air here is not covered by copyright because it's not fixed in a tangible medium. The recording of my speaking into the air is covered by copyright because at that point it's fixed, okay? I think something that throws people a little bit is copyright protection is automatic. Under the current law, it's automatic from the moment of creation. So the little C inside a circle is no longer required. Registration with the Copyright Office is not required. So as soon as something is fixed in a tangible format, and I think sometimes we don't think of the digital stuff being tangible, but it does exist in bits and bytes somewhere on some physical object. So it is a tangible format. So this is all covered by copyright. So your classwork, your notes, your grocery list, love letters, all different kinds of things, images on the internet, all kinds of stuff that you might think, oh, I just can download that for free, that should be fine. It's actually not. It's still protected by copyright, so you do need to think about that. I think we're so used to passing things around pretty freely that we don't always think about, someone did make an effort to create that. They've got some rights invested in that. There are exclusive rights for the copyright holder. And if you look at these, it's important to sort of distinguish these, I think. So to reproduce things, to create derivative works, so like if you're making an anthology of something, that could be a derivative work. Or if you're taking a novel and you're making it into a graphic novel, that might be a derivative work. To pass copies on, to distribute them by sale or in other ways, that's an exclusive right of the copyright holder. To perform things or display them, so to hold something up and show it to people, that's actually an exclusive right of the copyright holder. So if you look at all this list of things, you could feel like, well, we can't really do anything. The copyright holder has all the rights to do everything. This is just the starting place. So then after that, the copyright law spells out some specific exemptions, and there are lots of different kinds of exemptions. We're going to focus on those that relate to teaching. So there's some specific exemptions for what can be done in a classroom or what can be done in the digital learning environment. There are also exemptions for like what a restaurant can do. So allowances for playing music over the speaker system, or like for religious services to be able to sing hymns and that kind of thing. There's some different specific exemptions, but we're just going to focus on a couple of them. And then after that, there are some fair use principles. So there's sort of, think of the exclusive rights and there's specific exemptions. Then there's some fair use principles that might guide you in what might be okay to do. I guess I mentioned already that copyright term has been extended and goes on for a long time. So I think that's sort of the basic framework to operate in. And then on this side, we have sort of a flow chart. If you're thinking through a decision, these are kind of the steps to go through. And each of these links here will pop you to a different tab on the top. So you can just click the links here, or you can kind of go through the sequence up at the top to find your way around. So first thing is to find out, is the thing you want to use covered by copyright at all? So some things the copyright has expired. So it might be in the public domain. At this point, we typically think of things that are prior to 1923 as being in the public domain. Also, most federal government documents, because they're produced with taxpayer dollars, they are automatically in the public domain. There's some exceptions, like the government contracts with a commercial publisher to publish something that might not be in the public domain. But most of these things can be freely used. The next thing would be to see, is it covered by a license? Is there a license that would allow you to do what you want to do with an item? Licenses, and Lana, you can correct me if I'm off on this, my understanding is that a license is a negotiated contract. So since two parties have come to an agreement in the license, that usually trumps other stipulations of copyright. So for example, the library licenses a lot of databases that allow us to provide online articles and that sorts of things. The licenses can get very specific on what we can do with those. So some licenses would allow us to provide articles to other libraries, to interlibrary loan. Other licenses might be stricter and say, no, only people who are affiliated with the university can have access to those articles. You can't copy them, download them, pass them on to anybody else. So the license could either be stricter than our general understanding of copyright law, or it could be more permissive. It could say, in this context, we're allowing these specific uses that you might not have generally. And it's sort of negotiated and spelled out. And often for the libraries, and we're paying for things, the payment for things is built in with a license as well. There are different kinds of licenses too. You might find that some departments may license things. Like this happens mainly with software. So I think like the engineering school has licensed some specific software packages. So they're available to people in the engineering school, but not more generally. Also, there are some blanket performance licenses, and that's handled through the General Counsel's office. I think these mainly pertain to performance of music. So like instead of having a music school have to go out and get a license for every single piece of music they're going to perform in concert, there's a blanket license that would cover all of those performances and the use of music for that kind of purpose. And it's like one fee goes to the professional association and covers all of that. The other thing I think is good for you all to be aware of is the idea of the Creative Commons license. We're going to come back and look at this in a little more detail as well. This is a newish thing. A lot of creators would like other people to be able to use their stuff, and they're not necessarily happy that the copyright law, the default is no, you have to get permission. So the Creative Commons has developed a variety of licenses that you can use proactively to give people permission. So you can say, yeah, you can use my stuff as long as you don't change it. You can use my stuff as long as you're not making money off of it. So there are a whole variety of different licenses. So that's becoming, I think, more prevalent. So it's easier to find some of those things that you might want to use with a Creative Commons license. Okay, the next step after checking if it's in the public domain or if it's covered by license would be these exemptions. And we're going to look at these in more depth too. So there is an exemption for what happens in the physical classroom, and then that was updated through the TEACH Act to apply to the online learning environment as well. And then the next step after that, if the exemptions don't let you do what you want to do, then you could do a fair use analysis and see, is my particular use, would it be considered fair? Can I do that? We'll look some more at that too. Finally, if none of these things apply, then you do need to get permission from the copyright holder. And that may just be a matter of a letter, and they might say, fine, yes, I'm glad for you to use this, or they might charge you royalties to do what you need. We'll go through that process as well. So any questions at this point? Just sort of the general layout of things and then the general process you would go through. It all kind of makes sense. Okay, let's start hopping through these. So in the public domain, this has largely to do with dates of when things pass into the public domain. And I like particularly this chart from Cornell. So if you click on this, you'll see it goes through like every possible permutation and different date ranges. So you'll often figure out what kind of thing it is you're dealing with and then what the date range is. Notice that things that have not yet been published, these would be like manuscripts or personal letters, something like that, those are more protected. They have a longer copyright term. The idea is this has not been, the creator or the author hasn't had the opportunity to make this available to the public yet. They should really get the first shot at doing that. So it's more protected than things that have actually been published. So if it's been published, then this reflects some of the changes in the law. So from 23, or prior to 23, it's all in the public domain already. From 23 to 77, the copyright notice, the C in the circle, was required. So if it got published without having that notice, that it's not covered by copyright. For other things, if it had a copyright initially, but it wasn't renewed when it first expired, then that might be freely available. And then things, sort of go through these different parameters. So when you are looking at something, you'd want to look through the dates and kind of see. And I think really anything published prior to 23 is pretty much free to use. After that, it gets a little bit messy, and particularly in the period between 1923 up to about 1990, because that was the period where someone might have renewed the copyright or they might not have. You have to kind of do some investigating to find out about that. Excuse me. Also, some different things might affect things. So like if it was published overseas, it may depend on what treaty we had with the country when it originated. I think right now, generally, most of the countries we see publications from are part of the International Intellectual Property Organization. So U.S. copyright would basically apply in those cases, but in some other cases they wouldn't. And then some other things that are kind of odd are like sound recordings. Sound recordings used to be copyrighted under state law rather than federal law. So it's a little bit of a wrinkle in that, and the period is a little different, and it might depend on where the recording was made. So for most things, it's fairly straightforward. There's some different options here to find out if copyright was renewed or not. And if you find this daunting and you're running into trouble with it, just send me an email, let me know. I'll be glad to sort of go through this for you and try to do this. There are different databases that record the records from the Copyright Office of what was renewed and what wasn't. So we're happy to help you out with that. And then here's a section on the Creative Commons. So you can go into the Creative Commons, and I want to show you what the different licenses look like here. So these are the different license types. So you can see they've got different symbols. So some are glad for you to use it in whatever way, as long as you correctly cite it, attribute it to the author who first created it. Some are glad for you to use their stuff to make new things, as long as you extend that same right to others. Some for a non-commercial purpose. Some will let you use the original, but they don't want you to alter it in any way to make a derivative work. So you'll see these different sort of license symbols. And then what's nice is they've got this built as a database. So if people have registered with them to have one of these licenses, they've included it in this database. And you can see, you can tick a box if you want things, if you want to use it for commercial purpose. You could search on this, like I'm looking for images of coneflowers, for example. Oops. There we go. So I get some images of coneflowers. And if I look at one of these, I'll see here some rights are reserved, and I can click on that and see what kind of license it has and what I'm free to do with it. So that's a really handy way if you want to find things that are free to use. That would be one way to do it. Yeah.
Does it cost a person money to get their work licensed under Creative Commons?
Okay. I'm going to repeat your question just for the benefit of those who are online. So the question is whether it costs something to get this kind of license. I think this is all freely available. I don't know, Grace, have you run into this at all?
So I'm actually doing a workshop next Friday.
On this?
On
Okay.
Commons. That just popped up as a donate to the
Right.
organization. It's free, and all you have to do is put the image and the window of the license on it, and you're good.
So it's one of those nice, I don't know, it feels like the hippies have come back or something to me. I'm old enough to remember the 60s that, it's let's all share alike and be friendly. So we're sharing all this stuff, and it is, you're actively putting something out there for others to use and being proactive about that. And then you can see it is supported more by donations, so people can contribute to keep this going, kind of like Wikipedia similarly. You can contribute to it to keep it going. Okay, let me go back here. So we do have the Creative Commons, and thanks, Grace, for reminding us about the workshop you'll be doing so people can come back and learn more about that. We've also given you some different links here to different things in the public domain. So there's this public domain Sherpa, collects a lot of things. It's like a search engine for public domain stuff, so you can find some other things. I also find I really like the HathiTrust Digital Library for finding things that are in the public domain. This is a project where different libraries are contributing materials and digitizing them. And you can see whatever you can see in full text within the HathiTrust Digital Library is in the public domain. So you'll see a lot of things prior to 1923, but then for those things in that middle ground, they are actually investigating item by item. Has the copyright been renewed? And if it has not been renewed, the item is passing the public domain, they're making it full text available so you can see it. So that's a pretty reliable way to tell if something's freely available or not. So any questions about this part, just determining? I think this is mainly just for you to see. There's the chart. It's kind of follow that through, look at your case, see if it's in the public domain or not. As I mentioned with the educational exemptions, there are two different parts. So there's the exemption for classroom performance and display, and this is what would allow a teacher to hold up a book in class or show a picture in class or have students perform a scene from Shakespeare. Shakespeare would be the public domain actually, but a more recent play that could do that. We see this come up most often now with videos. The question, can I show this video in a class? So normally the public performance, the public is often outside of the circle of a family. So it doesn't mean you're charging admission or it's a big space, but just it's beyond a family grouping. That would normally be the exclusive right of the copyright holder, but there is an exemption for a classroom performance. So, and again, keeping the balance in mind, it's helpful. So it's okay because it's a bounded audience. It's the people enrolled in the class. They're physically located. It's not a film they're going to take with them. They're going to see it in that class, and then they're not taking it away with them. It does need to be something that's part of instruction. So you can't just show a movie for fun because you're not feeling well that day as an instructor. It needs to be integrated into the class content and be part of that mediated instruction. So you've got that instructional purpose there. We find some of the movie vendors will insist that you need to have public performance rights to show it in a classroom. Our understanding is that is not true, that showing a video in a class situation should not require public performance rights. When we're buying films as a library, we typically do not buy the public performance rights because we're getting things for personal study for an educational purpose. Some vendors will not sell to us unless we pay the extra to get the public performance rights, and that's noted in our catalog records. So if we have that, that means that would be available for showing to like a club, some non-class sort of thing, but generally you shouldn't need that. The Academic Support Center does typically buy performance rights because they do rent their video collection out to other schools and other places. So they typically do have the public performance rights. We're more and more getting streaming videos. As some of you might know, we have the Canopy video streaming service, and that is a licensed agreement. So the license does mean it can be streamed to anybody who's affiliated with the university. So that's a little bit of a different wrinkle because it's got that license agreement. And this is also a relatively new thing. A lot of people would have questions, can I, as a faculty member or as a student, capture some clips from a DVD, for example, to make a compilation and then show in class. And this involves several different layers of copyright. So one part is you have to break the encryption on the DVD in order to capture the video to start with. And that would typically be a violation of the Digital Millennium Copyright Act. And then you're reproducing it and you're showing it. So there's several different layers going on here. There was an exemption passed in 2009 that allows faculty, in the case of a DVD, to do that. So for an educational purpose, you're capturing some clips to use in that class context. That should be okay. And for students who are studying film or media studies, it allows students to do that too, recognizing they really need to do that for their educational purpose. So a biology student, no, not so much. But if you are specifically studying film and media, they provide a little bit more of an exemption for that. So, and that's part of the rulemaking. If you're familiar with how US law works, there's bills are passed, they become a statute that's included in the code, and then rules and regulations are passed that make that law a little bit more specific. And the rulemaking may be ongoing. So copyright law responds to changes in technology a lot, so they have provided for periodic rulemaking. So some of these rules, they realize technology is moving pretty fast, so periodically the rules get reviewed and updated to try to take that into consideration. So we've got a link here that takes you to the page that shows the most recent rules on that. So that's for physical showing things in class, and bear in mind too, it's just for performance and display. So this is not having to do with making copies to hand out in class. That's a different thing. So that reproducing is different from performance and display. That gets a little bit blurry when you're looking at the digital format because you're displaying something. You might want people to download it. It's kind of like you are making a copy. The way the internet works is it makes copies and pushes them out. So it's a little bit blurry there. But this is trying to make the digital environment a little bit more like a bounded physical classroom. So you can do a lot of things in the digital format, but you do have to meet certain parameters. So it needs to be through something like Canvas or Blackboard where the access is limited to the people who are enrolled in the class just for the time that they're actually enrolled in the class. So once the class is done, students no longer have access to that. It needs to be done by a nonprofit educational institution. So that's us. We meet that requirement as a university. It allows for the full performance or display of different things and then for more limited portions of other things. So you can see for dramatic works, whether they're theatrical, movie, or music, if they're more dramatic, it's more limited. I think the reason for this is because the copyright law is protecting the expression of things, not the ideas underlying the expression. If it's something more factual, like a documentary, it's easier to separate the expression from the idea. If you've got something that's more artistic, dramatic, it's a little bit harder to separate that expression from what it's expressing. So it gets a little bit more protection. So typically they would say you could show the excerpts. If in class you wanted to comment on something, you could pull a clip from a movie, make comments on that, and then you might link to the full movie and have students watch that outside of class. Does that kind of make sense? Also, you should not be doing things that were designed to be textbooks, workbooks, what we would call consumables. If something's been published with the idea the student's going to use it up, it's obviously going to undercut the market if you make that available on your website. And people won't buy the consumable anymore. So you do need to meet all these different obligations. ETMO is really helpful with this. They're well versed in all of this, so they're helping you set up a class. They can help you with all of these parameters. Right at the top, I do want to point out, in the electronic environment, we really recommend linking to things whenever possible. So we have a whole separate guide just on how to link to all the licensed things that we have that the library provides. Or you could use e-reserves as well, in which case we take care of some of the copyright issues with that. Sometimes if you're reusing something semester after semester, we really should pay royalties on that for that sort of reuse. So we take care of that as part of that process. Linking to things does a couple things. You're not copying something. So you're not taking something from the creator and reproducing it and releasing it freely into the wild. You're just pointing to it where they still have control over it. So that's a better thing. It's also good for the libraries because we capture usage statistics on this. We don't look at who's using what, but we've got tight budget times. We have to make budget decisions. We do that sometimes based on cost per use. So if you download something and repost it, we see one use, we see one download. We don't see that lots of students are using that. If you link to it, the systems collect all that data and we can see, oh yeah, that gets used wildly. That's something we really need to have. So that comes into our financial considerations. Any questions on this? Okay. I think that you had I'm sorry, I'm not remembering your name, the gentleman over here from the College of Ed. You had a question about, not in a class situation, but in an educational use beyond that, like for a publication, right?
Yeah. In that case, like if we had a blog that we wanted to make other people's materials available on a certain topic, perhaps to share in the school.
Right.
He said that linking would be preferred to download.
Right.
Anything else I need to think of?
Yeah, we're going to get into fair use in just a moment. Let me just repeat the question for those who are online or picking up on a microphone here that you can't see. So the question is, if you were outside of the classroom, you still have an educational purpose, like an educational blog or publication that's going out to teachers, for example, what would apply then? And these exemptions are strictly for the classroom setting or for the digital learning environment. And it may be these might not give you as much leeway as you would like. They're not this stopping place. So you can look at the exemptions. If the exemption is spelled out what you want to do, then you know that's okay to do. But if it's not spelled out, then the next step is to go to fair use. And this is something we should look at in more depth. To evaluate whether a use is fair, there are 4 different qualities to look for, 4 different factors to consider. And I think a lot of people are aware of educational use being one of those. And we hear a lot of people say, well, it's for an educational purpose, so it's fine. Well, that's just one factor. You really need to look at all 4 factors and consider all of them. So the first is the purpose of your use and the character of your use. So if it is for nonprofit educational purposes, that is a favored use. That will usually weigh in favor of fair use. The next one is the nature of the work you're using. Excuse me. As I mentioned, I think things that are more creative or fictitious tend to be more protected than things that are factual. And again, part of what copyright wants to do is allow the free exchange of ideas and promote that. So again, it's the copyright law protects the expression, not the facts or the opinions underlying that expression. So the factual stuff will be less protected, will be more able to be used. The amount and substantiality of the portion used is also important, and I think this gets tricky. And keep in mind, it's not just the amount, but it's also the substantiality. So the way I think about this is like if I have made a lovely chocolate layer cake, and I say, would you like to share my cake? I expect you just to like take a piece off the end, take some icing and some cake and enjoy that and leave me the larger portion of it. I don't expect you to take like 3/4 of the cake, nor do I expect you to scrape all the icing off the top and leave me with just dry cake. So it's both the portion as related to the whole. It's also how substantial the portion is. So one example that I think is interesting was when Gerald Ford published his memoirs, he was publishing a book about how he pardoned Richard Nixon after the Watergate affair. And the Nation magazine scooped the manuscript before it was published, and they published the chapter on the pardoning. And the publisher sued, and the Nation said, oh, this is fair use. It was not the whole thing, it was just a portion of it. And the publisher made the point, well, first, it was still in manuscript form, it hadn't been published yet, so they hadn't gotten the right of first sale, but also it was the part everyone wanted to read, and everyone was waiting for. So, it wasn't a large portion of the book as a whole, but it was a substantive portion. It was the cream of the book that people wanted to see. So you have to kind of keep that part in mind. The last factor, which I think weighs as heavily as the first, is the effect of your use on the market or value of the original. And keep in mind, again, the idea is the person who made the effort to create this should be getting some return on their investment. So we don't want to undermine their possibility for doing that. So I think this can be a little tricky to figure out. What we recommend using is this fair use checklist. So I want to take you to this, and if you want to pull this up on your screen, you can do this. This was produced at Columbia University. Kenneth Cruz, who is the man in charge of their copyright advisory services, is one of my personal heroes. So he has both a library degree and a law degree, so he's very well qualified, and this is all he does. He just takes care of all the copyright issues. So he has made this, this describes a lot of different things, but I'm just going to take you straight to the fair use checklist, and you can see he's got a Creative Commons license on it, so we can reuse it. this is handy both as kind of a roadmap to help you evaluate things and also for your record keeping. So if you are thinking about using something, and this would apply to your blog question or a publication, you want to fill this out. You can see you've got your name, the date, everything like that. Keep track of this. So if anyone ever did challenge you later and said, I don't think this was fair, I think you were infringing, you can at least show your attempt that in good faith, you did take a look at this, you analyzed it as far as you could tell your use was fair. And that should help if there should ever be a legal dispute. So you can see it goes down through each different thing, and you basically go through and tick the boxes. So, you know, I'm wanting to reproduce a film, I'm using it for research, teaching, scholarship, I'm commenting on it, doing criticism, etc. That all weighs in favor. I'm not just using it for entertainment, I'm going to credit the author, so that would weigh in favor of fair use. If it's published, it weighs in favor. If it's more factual, it weighs in favor. So again, if it's fiction or highly creative, that would tend to not weigh in favor. Here's the amount again. The amount gets a little tricky, particularly if you're dealing with images. And I'm going to take you in a moment to show you some guidelines, because you've got an image that you want to reproduce. Well, you don't want to reproduce just part of the image. You really want the whole image. So when we look at images, are we looking at each image as a separate thing? Are we looking at a couple of images as part of a publication, or a couple of images as part of a photographer's work overall? I think that can get a little bit fuzzy. I think what might be more helpful is to think it's the amount that's appropriate for your educational purpose. So particularly in a teaching environment or when you're publishing something, you're going to want to use something, just the amount that's absolutely necessary for you to make your point. So like if you are writing a dissertation about art history, you're talking about artwork, you probably need that image there in order to be able to comment on it. So that would tend to favor fair use more than otherwise. And then look at this other thing on the effect. So if you're only making a couple of copies, you're using it in the classroom setting, it's a more limited audience, that's probably more a fair use. If it could replace the sale of a work, probably not. And especially if there's a reasonable licensing mechanism, and I think we're seeing this come up more. So I think, if you can easily and inexpensively get permission or pay a fee to get the license, that's probably the way to go. Again, you're supporting the creative people by paying them for this. So that's, some have argued too that, you're not undermining the market for the original, but you're undermining the market for the permissions. So we're seeing some of that come up a bit. Notice too that repeated or long-term use is usually going to weigh against fair use. So again, if you are making an anthology that you're going to use over and over and over again, or you're setting up a reserve thing in the library, or reusing an article in your Canvas page, you're basically making a substitute for a textbook. And in that case, that's probably not a fair use. So we don't get into offering legal advice of saying, yeah, your use is fair or your use is not. We kind of point you to this, and then it is a little bit of a risk assessment on your part. You say, I've gone through this, I think this is a fair use. I'm going to go ahead and do it. If you're a more risk-averse person and you go through this and you don't feel comfortable, then the next step is to look into getting permissions and see. Or you could talk to someone who's got more legal credentials and get their take on this. What I've seen, we've had a workshop before with an outside speaker who came in who was really saying, push the fair use, push the envelope. Do as much as you can under fair use. And past legal counsel, Nancy Hawk, said, well, that might be okay in a different circuit. We happen to be in a circuit that tends to be stricter. So at that point, she was not that comfortable with pushing the envelope on fair use. So it's sort of, I don't know, Lana, would you like to weigh in on your opinion on this?
My thought is...
Do you want to come over here and talk to the microphone? I'll pick you up.
My job is sort of protect the institution, right?
Mm-hmm,
so
right.
If there's going to be a decision, I'm sort of going to be sort of viewpoint.
Right.
And I don't think that, even if you ask permission and are denied, I don't think that guts a fair use argument, right?
Okay.
So I think I tend to lean on ask permission because, these factors are very difficult to apply and so fact intensive.
Yep. Yep. So that's probably, I don't know if that's helpful to know. We're all stuck with this kind of fair use thing, and I think it really does come down to what you're personally comfortable with. And again, if you're representing the university, it can be different. Yes. Okay. Do you want to repeat that over here just so the microphone picks you up? We've got people online who can't hear. Right here. You just stand here. The microphone should pick it up.
So I think my 2 cents was, I represent the institution, and so because of that, I tend to be sort of fairly conservative in my advice. And so if you can sort of go through the factor analysis and you're really not sure, you're sort of wishy-washy on it, my advice would be just ask for permission. I think the other caveat to that is the law says, even if you ask for permission and denied, it's not like that means you can't rely on fair use later on.
Okay.
So sort of my 2
That's
cents.
good to know. I didn't know that last point, that you could still look at fair use even if you have been denied. Yes.
Let me ask real quickly, when you ask for permission, sometimes it's pretty easy. Sometimes it's a real pain. Does
Right.
the library have, who do I call? Because if I quote somebody out of a little thing, I can email the author and sometimes, hey, quote away.
Right.
Somebody to see my publisher, go to the publisher, they got nobody to ask.
Right. Yep. So the question is, what do you do about getting permissions? So we're coming right to that. So we will go to that next and look at the permissions page. I guess one question would be when you need to ask for permission. So I think if you are quoting somebody and you're not quoting more than a paragraph, I wouldn't think you would need to get permission, because that's a very limited portion. You're just making commentary on it. So I don't think that would even require permission. If you're reproducing an entire article from some other publication, I would think that might, in a commercial environment where you're going to republish it and redistribute it, that would probably require permission. And we're happy to help with that. We know it's not always real easy. So you could just email me and I will look into that and see what I can find out. There are some different things. I should talk about a variety of things here in this context. One is, figuring out who holds the copyright is one part of this. And often that, in a publication situation, that's probably not too difficult because it's usually the publisher who has those rights and they're relatively easy to contact. You may sometimes have things where, say, a freelance writer has written something in the newspaper, and the freelance writer actually still holds the copyright. They've given the newspaper the rights to reproduce it, but they still hold the copyright. I see this sometimes happens too with photographers or artists. The journal might hold the copyright to the article, but the photographer has retained the rights to the photograph. So sometimes there's a little parsing out of that and figuring out who actually has the rights to say okay on this. You could also get into something where you've got layers of copyright. So for example, if you're wanting to reproduce a recording of music, of contemporary music, the composer has rights, the performers have rights, the recording company has rights. So you've got multiple layers. Now, thankfully, a lot of those sorts of things are often handled by these collective licensing agencies. So for published matters, the Copyright Clearance House handles a lot of copyrights for different publishers. So rather than contacting the publisher, it goes to the Copyright Clearance Center. They will usually charge you a fee. They are in the business of making money, so they will push that. But it's a pretty easy process to do. So that's where we go if we need to get copyright clearance for an interlibrary loaner to put something on reserve. ASCAP and BMI would be the big ones for music stuff, for example, and composers and performers register with them and they pass on the royalties to those people. They kind of manage that whole thing. And you can see a lot, particularly for different creative groups, so for drama, film, etc. But we're happy to help you locate where you would need to go to get permissions for things. And then you do want to get permission in writing. You might make an initial contact by phone, but you do want to get something in writing. Could be by email, but you want to hang on to that. And again, the Columbia Copyright Center has provided some model permission letters that we advise using. So you have to make sure you've told them who you are, what you're going to do with it, how long you're going to use it, and know if you got permission for one use, that doesn't mean you automatically have permission for other uses down the line. You might have to get permission again for another use. So that kind of takes you through that process. Does that answer your question, more or less? More or less. Any other questions on this process? Okay, we are getting near the end, and I do want to just talk a little bit. I want to point out two other things. There are some special cases and some other things having to do with technology that you could explore on your own. I do want to point out these guidelines. Sometimes these are helpful. These guidelines for classroom copying, so this would handle like copying for handouts in class. these were developed when the photocopier came out, and all the publishers were right, oh no, everyone's going to photocopy everything and there will be no market. So you can see every time there's a new technology, people get kind of upset and we have to make adjustments. These are actually included in our collective rules and regs for the university, but they were really designed more for high schools. And I think a lot of people in higher ed would say, yeah, these are really a little limiting. And fair use would probably allow you to go beyond this. So you can see it's like one chapter from a book, one poem from an article, etc. But it's still the same kind of balancing act. So be mindful of the amount. Be mindful if you're going to use it over and over, then that can have more impact on the market. So you might not want to do that. So it's the same kind of thinking behind this. These other guidelines you might find interesting to look at. So there are different groups, particularly in the 90s, that try to develop different guidelines, particularly for the digital world. And it was an attempt to come to an agreement between libraries and educators who might be using things and the publishers who were producing things. They weren't totally successful in coming to an agreement. So in some of these cases, this might be more a recommendation from one party. Oops, looks like I need to update. That link there. That's not going to the right place. So different groups have come up with guidelines to try to give people some more ideas. It doesn't necessarily mean that the publishers have agreed completely to these. So I think they're somewhat helpful just to get an idea of how the general academic community is interpreting things and what they're thinking about it. It doesn't have the same force as the law itself, but it might help your thinking about fair use to see this is kind of what other people in this field think about this. So that would be something to look into. The last thing I want to do just real quickly, we've got about 5 minutes left, is I do want to talk about your own copyright and the things that you might be doing and what you can do with it. You should be aware, if you're at the university, take a look at the university policy on patent and copyright. The way when you're an employee, some of your work might be your own, but some of it is what's called a work for hire. It's done as a condition of your employment. So you'll see, like on all the library web pages, the copyright is held by the curators of the University of Missouri. So I made this page, but I don't own the copyright to it. The university does, because that's just part of my job. I think for instructors, for professors, it might be a little bit different. It gets spelled out depending on, were you commissioned by the university to do this? Is it as a result of an internal grant? Are you using a lot of university resources to create this? So when you're starting a project as an instructor, particularly, you'll probably want to look, make sure you're clear. Is this something that you will own as intellectual property that you can take with you? Or is it something the university owns? Or do you need to negotiate what kinds of rights there might be? For students, it's a little clearer. Students hold the copyright to their own work. So if you're doing a work for an assignment, that's still your work. And really, a professor shouldn't project it on the screen or pass it on to others without getting your permission. As far as sharing your work, there are a number of things. Registration with the Copyright Office is not required. It can be beneficial if you should ever want to sue. I think you have to have your work registered. It's also just another way just to put your name on it. So, yep, this is mine. I'm asserting my ownership of this. Also, when you publish, like if you're publishing with a journal, you need to be aware of your rights. And we link out to this organization called SPARC. This is, I can remember what SPARC stands for. Grace, tell us what it is.
For the microphone.
You can come, stand over here.
It stands for Scholarly Publishing and Academic Resources Coalition.
Thank you. So this is an advocacy group pushing for authors' rights. What we find, particularly in scholarly publishing, when you submit your article to a journal, they have you sign an agreement. And the default on a lot of that seemed to be to sign the copyright over to the publisher, which is very convenient for the publisher because then they have the sole right to do whatever they might want to do with it later. But that meant that the author didn't have the right to put it in the institutional repository, hand it out to others in class, send copies to friends, revise it, republish it. So what SPARC has done, they've created an author addendum, which we recommend using. And they have more information on here. And then they have created this addendum. I think probably publishers are getting used to seeing this, where it just reserves certain rights to the author. So it's just, I want to attach this to my contract with the publisher. It gives the publisher the rights to do what publishers typically need to do, but it reserves rights to the author to do the sorts of things an author might want to do, particularly as an educator. So those rights, it's not like copyright is one bundle of rights that has to all stay together. You can't unbundle them and parse them out and say, yeah, I'm going to give you the right to do this. I'm retaining the right to do that. So it's a good thing, examine any publication agreement carefully. We've done some other workshops where we've actually gotten publication agreements from different publishers, and we've gone through and marked them up to say, yeah, nope, I don't want to agree to that. I'm going to change that. And I think a lot of times people who haven't had as much experience with negotiating these just think, oh, well, that's just the agreement. I just have to sign on the dotted line. Well, no, you can amend that. You can scratch things out, change things. So that's something we want you to be aware of. And then we've already talked a little bit about the Creative Commons license, and Grace will do more on that. So know that you can proactively grant permission for specific types of use by using a Creative Commons license. And that does then add your work to that database so people can search it. Yeah.
We have an online question that asks, do publishers sometimes reject papers altogether if the agenda uses?
That is a good question. So I'll repeat the question. The question is, do publishers ever reject a publication because the addendum has been used? And I don't know the answer to that. I don't know, Grace, do you have any experience with that? Do you know?
Sorry.
We will have to look into that. Do you have experience with
A
this?
little bit. I'm a medical illustrator.
Okay.
It's a big topic in the medical illustrator world.
Okay.
We try to keep copyright, so
Right.
the rights. So yeah, that can happen. It's publishers really.
Right. Yeah. Okay. I'll repeat for the microphone again. We have a medical illustrator in our audience, and she's saying that can happen. If you want to retain the rights, a publisher may say no, they won't accept it without having more leeway to do what they want. Yeah. I'll have to look into that some more. We can see if we can find out more about the trends of that. My impression from the workshops I've been to is that this is becoming more common for people to use this addendum, so different publishers are getting more used to seeing that. So I hope that's working out better. My voice is going and our time's almost up, so I'm going to stop here, I think. I will mention we've got some information on open access publishing, which is just another way to make your work more available. It's not really a copyright issue, it's more of an economic issue of pushing things out, and the university or the author assumes the cost of putting stuff out rather than having a buyer or user buy or pay for something. Also, government-funded stuff, there's been more of a push in recent years to make more tax-funded things more freely available. So we do have separate guides as well to public access policy. So this has been a directive to government agencies to have a plan in place to make work that they have funded more available to the general public. And there's a bill which seems to be hung up in committee right now to try to make this more of a general policy for all federally funded publications. So there is a general movement to try to make things more accessible, just realizing copyright, it's been extended, it's gotten a little bit more hairy. Certainly in academic circles, certain publishers have kind of cornered the market and they're kind of making things less available. So there's a general movement to try to push against that and really get back to the purpose of copyright, to promote the sciences and useful arts, make sure that things can continue to grow without being too restricted. Any questions at this point? Okay, well, thank you. Oh, Grace has a question. Go ahead.
I have a hard question.
Okay.
I hear a lot from instructors and students, all of this is complicated. I'm just going to kind of do my thing, and what's going to happen? Are the copyright police going to come after me? I have yet to have a good response to that.
Well, here's the question is, how likely are you to get in trouble if you just disregard this whole hairy mess? On the first page here, we do have this box on the penalties of infringement. So this is where Lana might be able to tell us more from case law stuff. I'm not as familiar with the case law, but certainly there are potential penalties. I have heard of people getting caught. I've heard of it more in the music world or in videos, people passing along video music and getting caught by the companies doing that and getting nailed with these pretty hefty fees. If you're not following the university's acceptable use policy, your access to university technology can be cut off. So that's a good reason at the university to play nice and not misuse our internet supply to do nefarious things. Also, as part of the Digital Millennium Copyright Act, we didn't really have time to talk about that, but that protects the university as the internet service provider on the condition that we will take down things that people say are infringing. So if I post something up that I think is okay, and whoever created that complains to the university, and you'll see on every university page, there is an identifier for the DMCA agent. So each internet service provider has an agent who handles these complaints. And what they have to do to respond, they immediately have to take down whatever has been challenged as infringing. And then there is an appeals process. So they would alert me, we've taken this down, we've had a complaint. I have a chance to appeal that and say, oh no, I thought that was fair use. So it kind of keeps it out of the courts. There's sort of a negotiated adjudication of that. But that can happen. And there is more information here on the acceptable use policy and the Department of IT policy on copyright. So I think that's where students would probably more likely see things. They might get caught on that. I'm more aware of things that we have with the library where we have license violations. Someone is downloading vast quantities of articles and the company turns it off for the whole university. So, and then we do mad scramble to find out who is it who was downloading the entire database, wrap them over the knuckles and see if we can get that turned back on so that everybody can have access again. So, you know, it is a big business and it does take a lot to create something and make it this readily available. So people are concerned to protect their financial interests in this. Does that sort of answer your question? Okay. All right. Okay, well, thank you for your patience in listening to all this. And it's a lot of stuff. It can be a little tricky to get your head around, but I hope that you're aware this guide is here. I hope it will kind of step you through the process to at least give you some initial kind of navigation for things. Certainly feel free to contact me, and I should have I don't think I've got my contact information on there. But I think if we go to, let me see, where are our directories? Huh. I don't know. We'll go to the main library homepage. I think I'm listed as the copyright person. If you go to the directories, there's subject libraries. Let's see if I'm listed under copyright. No, I'm not. Well, I'll tell you then, if you have a question with this, if you go to the main library page and you go to Ask the Librarians, you can email us, chat, text, whatever. And we're monitoring this pretty much around the clock, and copyright questions will probably get routed to me. And I will do some digging, see if I can find an answer. If I can't find the answer, I'll refer you to General Legal Counsel, and we'll team up and get you an answer. Okay. All right. Thank you very much. I should say too, if you are interested in how this applies to your thesis or dissertation, we've got another workshop in 2 weeks. Same time, same place, that's focusing just on copyright issues with that. And then you're doing one on Creative Commons next Friday. Yep, we've got others on open access, public data accessibility policies, so you can keep an eye out for other workshops that might be useful to you.